Okay, can you hear me? Mr. H, can you hear me? Mr. H?
Hello, Moses. Can you hear me?
Yes, I can hear you. Can you hear me?
Yes. No, perfect. Sound is perfect.
Good, good, good,
Yeah. So we
good.
will just record once the meeting starts. Now the recording is on pause now at the moment.
Yes, we'll record once the proceeding starts.
Yes. No, everything is set,
Okay.
Brahmas. Everything is set, eh?
Everything we are ready. Yeah,
Yeah.
we are ready.
Perfect.
Yes, I'm
Perfect.
impressed. We are ready.
I'm gonna mute myself now.
Perfect. I'm also going to unmute myself, to mute myself.
Honorable members, we are about to start with our meeting quorum, so that thereafter we start. I see how many members is one. That's myself, Honorable Chef, Honorable Sileku, Honorable Bartlett, Honorable Sandlani. Let's just wait for 2 minutes so that we do that coordination of making sure that all members log in. Honorable members, I think we are ready to start with the meeting. And I wish to take this opportunity to heartily welcome all of you to this very important meeting where we do strictly lawmaking. We process the 2 bills that are before us. We've invited the department to take us through on the C list, the final stage, in which a consolidation of all the different inputs from the provinces have been made. In our meeting, we have Honorable Mfaela, Honorable Nkosi, Honorable Motsamai, Honorable Sileku, Honorable Fesser, Honorable Sandla Nasmith, Honorable Shaik, myself, and who else am I missing? I think we are quite sufficient. We form a quorum and we can then proceed.
You must meet.
Oh, Honorable Bartlett, sorry, my apologies. Honorable Bartlett, and who else? Yes, those are the members. We are about 9. We are about 9 in this meeting. As I indicated, we are coming to consider the bills that are before us. The first one being the Municipal Structures Amendment Bill, and the second one being the Customary Initiation Bill. As you are aware, last week, we received the negotiating mandates from the 9 provinces, because preceding that process was the engagement at the provincial level, where provinces were considering the views and making their opinions made. And I must say that we are quite excited that all the provinces are supporting the two bills that are before us. Last week, we undertook a laborious process of receiving the submissions from each and every province on each and every clause that is encapsulated in the bills, and we had the possibility to engage with the proposed amendments. Now, what we are going to do this evening is that we are going to start with the Municipal Structures Amendment Bill, where we are doing what is called the C list, the consolidation from by the department, and thereafter we will have some deliberations on the proposals. After discussing, we consider to adopt or not to adopt the bill. We would then consider the customary initiation bill, follow the same process. Now, I must just emphasize the point. We are dealing with the Municipal Structures Amendment Bill. My experience of the last few months is that some people confuse the Municipal Structures Act and the Municipal Systems Act. Sometimes people refer to what we're doing as Municipal Systems Act when we are dealing with issues pertaining to the Municipal Structures Act. These are the two totally different bills or acts which serve different objectives and purposes, but towards ensuring that they support and consolidate local government. The Municipal Structures Act deals with the structures on how municipalities are established, on what structures are needed in terms of the municipalities, the municipal boundaries. As we are aware, the IC also had an input, a very, very good, solid input in that respect. And it deals with all the structures, the types of municipalities and the categories of different municipalities. Whereas the Municipal Systems Act, it deals largely with the processes, the systems that are in place, human resource, community participation, labor relation, integrated planning, and all the necessary systems at municipal level. And my just observation is that people tend to confuse the Municipal Structures Act, which is Act number 117 of 1998, and the Municipal Systems Act, which is Act number 32 of 2000. These are the totally different bills that we must, all of us, acquaint ourselves with those particular bills. Without further ado, let me invite, we received an apology from the minister as well as the DG. They are not going to be part of this meeting, but we are in the capable hands of senior departmental officials who are going to present what is called the C list to this meeting in respect of the two bills. We are going to start with the Municipal Structures Amendment Bill, and over to you, officials from the department. You'll introduce yourself and then take us through the consolidated amendments. Thank you. The C list.
Thank you very much, Honorable Chairperson, and good evening to other honorable members and my colleagues. Honorable Chair, prior to the meeting, we've distributed two documents. The one being the actual C list, which we concluded together with the parliamentary legal advisor, and then this document that we have flighted on the screen now. And for lack of the D-bill at this point in time, we incorporated the C list items into this document. So Moses, if you can just scroll down the screen. This document was put together with the parliamentary legal advisor, and we've indicated in the following pages those amendments highlighted in green, and as they would read once incorporated into the D-Bill. So, for example, we have the amendment to the long title of the Act, and once amended, it would provide for what we see highlighted in green as an addition. So we will include now to provide for transitional arrangements in respect of municipalities with a plenary executive system. The next amendment relates to clause 1, which deals with definitions. And as the members would recall, this was actually a definition that was sponsored by the Free State province. It is something that we've now agreed to in our engagement last week, and now provided for it to say that an authorized representative in relation to a party means a natural person duly authorized by the party in accordance with its constitution to act on the party's behalf for purposes of performing the duties contemplated in sections 27.2 and 43.2 D and E in the Act. So this definition is also aligned to what we find in the Local Government Municipal Electoral Act. The next definition that we've included is the Code of Conduct, and this is also an import from the Systems Act. We've amended the declared elected definition by including the words by the Electoral Commission, and this was sponsored by the Western Cape. We've then amended clause 8 by inserting the code of conduct for councillors in a new section 21A, and this is also imported from the Municipal Systems Act. We've amended clause 9 to align with the definition by including also the words by the Electoral Commission, and this is in respect of the election of metropolitan and local councils. In clause 10, we've done the same for the election and appointment of district councils. Moses, so you would see the addition of the words at the bottom of the page. If we can scroll the page, Moses. So clause 12 deals with the vacation of office, and we've aligned this provision to deal with the authorized representative definition that we've provided up front. And as you will see lower in the page, as highlighted in green there, that we've now removed reference to the Local Government Municipal Electoral Act of 2000. We've cleaned up clause 13 to remove of the municipality, as we saw it being superfluous, and as well as removal of the words on good cause shown designated person to, and these were sponsors from the Northwest as well as from the Western Cape province. Clause 19 deals with the composition of executive committees, and this too is in line with the amendments that we made in the B list. So we would now remove the word elect and replace it with determine, and where we have elected, we will replace that with determined. You will now see in D and E there that we've now inserted the words through an authorized representative, aligning with the definition up front and as sponsored by the Free State. The next clauses deals with an alignment of the amendment to section 43, where we also now replace the words elect with determine and elected with determined. So the next few lines on this page actually deals with this technical amendment. At the bottom of the page, you will see that we provide for a new clause. Further down the page, and you will see that this is in alignment with the importing of the Code of Conduct from the Systems Act into the Structures Act now. And this provision here was actually a provision that we had omitted in the B version of the bill. The next amendment is to clause 23. And this was also a drafting or technical revision that we've made, where you will see further down the page that we replace section 3C with a newly formulated 3C so that it reads in proper English. The next amendment is in relation to clause 27. It was actually an oversight that was picked up by the IEC, where A minus B actually relates to votes. So the seats in B is replaced with the vote, with the word votes. Clause 30 deals with the Code of Conduct for councillors, and here too it is a drafting improvement to remove a comma after the word may and to insert it after the word not. On the next page, on the breaches of the code, we also make a technical change to replace the word chairperson with the word speaker so that there's consistency throughout the Code of Conduct. On the next page, around investigations of breach, we insert the words by the MEC at the end of the sentence there. And this was sponsored by the Western Cape. In clause, subclause 8, we make the correct reference now to the subclause 7 and not 6. And we replace the words, the rules of natural justice, with section 3 of the Promotion of Administrative Justice Act of 2000. The new clause, in clause 31, we amended by including section 54, which we've now imported from the Systems Act into the proposed D bill. And then we have a new clause now dealing with transitional arrangements, and as was proposed by the parliamentary legal advisor, to say that a municipality with a plenary executive system immediately before the commencement of the Act will continue to exist as a municipality with a plenary system until the date of the first local government election after the commencement of this Act. And then lastly, on the short title and commencement, we change 2018 to 2020. And if this happens later, then I'm sure CREDA would automatically make that update when the bill is finalized. Honorable Chairperson and members, that's our input on the Municipal Structures Amendment Bill, pursuant to the discussions that we held last week and our engagements with the parliamentary legal advisor. Thank you very much.
Thank you very much, Mr. Kevin Naidoo. I think you were spot on, very clear about what proposals are needed and the insertions that you have made in respect of tightening up this piece of legislation. Honourable members, that is the situation. Any point of view before that from a parliamentary legal advisor? Any comment, any words, or any addition?
Good evening, Chairperson. Chair, we were quite fortunate to work very closely with Dr. Naidoo last week. So we have settled all the matters between ourselves and we support the C list as presented. The only one comment that I do have, Chair, is on the issue of the transitional arrangements. That is, of course, a content issue. I had noted that the that the bill contained no transitional arrangements, and my view was that something had to be inserted there. If the committee wishes to discuss the content of that clause further, it may do so. Because as I say, it's a content issue that the department is best placed to advise the committee on. But otherwise, from my side, Chair, I'm satisfied with all the changes that have been proposed. And I think it's a true reflection of our meeting last week. Thank you.
All right, thank you very much. That's it, honorable members. Any comments, questions, clarifications?
We are fine, Chair. I'm fine.
Deliberations? Yes, Honorable Bartlett?
No, I'm fine, Chair. Thanks.
Oh, you're okay.
Yeah.
Any view?
Yeah, Chairperson.
Yes,
my-
Honorable State?
Yeah, no, thank you, Chair. I think I'm also satisfied. I think on the issue of the transitional arrangements, I think it was also discussed in our previous meeting, and we were in agreement to the fact that it should be included in the bill. And I think in terms of the phrasing as done by the department, I'm okay with it. But just one comment, Chair, just in terms of procedure, I know when was it Kevin who made the presentation, I think at the stage of the C list, I mean, we don't necessarily talk about provinces because we've already been through, it's actually a committee decision. What goes into the C list comes out of a decision of the committee and not necessarily from each and every province that sponsors the position. This is a negotiated. Thanks.
Yes,
Chair.
that's correct. No, that's correct, yes. There's now a deliberation. This is our discussion. Everything belongs now to the committees. What we deliberated last week after receiving the negotiating mandates from provinces. Any other input? If you are satisfied, can we move for the adoption of the report?
I propose the adoption of the report.
Honorable Mfaela proposes that we
Chair.
adopt.
Chair, second.
I second, Chairperson.
Honorable Sheikh or Honorable Ethel, because he's seconding. All right, thank you very much. Any dissenting view? Any abstention? All right, thank you very much. This has been adopted. We are done with the Municipal Structures Amendment Bill as discussed and consolidated. And now this is the report of the committee that must be presented before the House for formal adoption. Thank you very much for that. The second bill, over to you, Mr. Naidu, the customary initiation bill. Take us through the same process like you did in respect of this one. Over to you.
Honorable Chairperson, I think the DG of Department of Traditional Affairs is in the House. And I'll allow him to make introductory remarks and introduce the person that will take us through the bill. Thank you very much.
All right, thank you very much. I wasn't aware of that. Good evening, DG.
Good evening, Chairperson. I hope I'm audible.
My apologies. I wasn't aware that you are here.
No, it's fine. It's fine, Chairperson. It's fine, Chairperson. Thank you very much.
Over to you. We are in your hands, and you'll guide us as to who's going to present. Thank you.
Yes, thank you very much, Chairperson. I hope I'm audible.
You are audible. You are.
Yes, thank you very much, Chairperson. I'm joined by our Deputy DG, Meshoki Muhaladi. She's also has joined the meeting, as well as Dr. Rinaldi Besser, who's our drafter, Chief Director. Without wasting any time, Chairperson, if with your permission, let's ask Dr. Rinaldi Besser to take us through the C list as proposed. Dr. Besser.
Thank you very much, DG. Good evening, Honourable Chairperson, Honourable members and colleagues. Chair, following last week's discussion of the Select Committee and the negotiating mandates, we prepared the C list, the technical one, where we indicate on which pages what must be done in which lines. It went to Ms. Harriet Mekwa, who's the State Law Advisor. She's also present in this meeting. She did quality control, and after that it went to the Parliamentary Legal Advisor, Ms. Ngema, who's also currently in the meeting, and then it was forwarded to the Secretariat. So we also prepared a similar document that Dr. Naidu presented, just to indicate to members exactly how these changes will read in the particular clauses if it's accepted as presented today. I'm starting with clause 1, which is the clause on definitions. In this case, I have copied the complete clause so that honourable members can see exactly where new insertions will come and where existing clauses have been amended. I'm starting with the new insertion, which is the definition for abuse. According to the definition that we have there, abuse will include, but is not limited to, physical or mental abuse, sexual abuse, any form of gender-based violence, and any harmful practice that an initiate may be subjected to. Then, Chair, on the area of jurisdiction, there's quite a number of things in the current bill refers to definitions as they appear in the Traditional Leadership and Governance Framework Act. Now, that act is going to be repealed by the Traditional and Khoisan Leadership Act, in short referred to as the TKLA. So what we have done, and we'll get to that at a later stage in clause 1, we've inserted a definition for the Traditional Khoisan Leadership Act, TKLA referring to that particular definition. And then all these amendments that need to be made to existing clauses or existing definitions, we have amended so that whenever the TKLA does commence, we do not need to go back to Parliament to change these definitions. So these definitions will read correctly at the moment under the Framework Act, and then if TKLA commences, we do not have to change that, it will still be applicable. The next one that the Secretariat has put on screen there, thank you Secretariat, is the definition for emergency services, which means that any services needed as a response to an urgent, impending, or recurrent situation for which knowledgeable and expert intervention is required to ensure the welfare of initiates and any other person present at an initiation school. This is including, but not limited to, emergency medical services, ambulance services, firefighting services, and disaster management services. This is quite a comprehensive definition. The one there for Kingship or Queenship Council is related to the definition being changed to include the TKLA once it commences. The same with the one for local house. The same with the next one, which is national house. They will see the next one if they go down. Same with that one. The same with Principal Traditional Council. The same with the next one, which is Provincial House. And then we get to a new definition, which is standards for initiation school premises. We spoke about it last week. That proposals were made that notice should be taken of the standards that have been issued by the Department of Health. So we've included the definition there to refer to the standards as they were published in the Government Gazette. Then follows the definition that I spoke about for the TKLA, which then means the Traditional Khoisan Leadership Act of 2019. The next three that we see on screen there, Traditional Community, Traditional Council, and Traditional Leader, are all consequential amendments or amendments aimed at reflecting the TKLA definitions as well once it commences. Then, Chair, we move to clause 2. This clause deals with application, objectives, interpretation, and prohibitions. In this instance, I copied all the sub-clauses that are going to be or have to be amended based on the discussions last week. In sub-clause 2, which relates to the main objectives of the Act, honourable members will remember now when we spoke about the definitions, there's a new definition for abuse, and that definition includes physical and mental abuse. So for that reason, in sub-clause 2, we are removing the words physical and mental in paragraph B, because it's already covered in the definition of abuse. Then sub-clause 4, what we are doing here is to keep the existing, just go up a little bit. Secretariat, just a little bit up. Thank you. We're keeping the existing, and we make it a paragraph A. Then we're removing the proviso that's in the existing one, and we make it a new paragraph B. And then the new part that is added is the one that was discussed last week, to say that a caregiver, traditional surgeon, or traditional health practitioner may only a period of 10 years has lapsed since he or she graduated from an initiation school. Then in subclause 7, right at the end, we are adding gender or sexual orientation. In other words, no person may be discriminated against on the grounds of disability, gender, or sexual orientation. Subclause 8 that is there on screen is a totally new insertion. It deals with the issue that was discussed around confidentiality regarding health status, where we are acknowledging the fact that there is a right to confidentiality, and that people who issue these certificates, as well as those who receive it, must treat the certificate as confidential. But important in paragraph C there is that we say this does not mean that a person does not have to comply with the provisions of section 22(1)(c) to F or 2. Just for the sake of honourable members, that section 22(1)(c) to F deals with the issues of issuing a certificate, a medical certificate, of indicating whether the initiate takes any kind of medication, to indicate whether the initiate has any serious health condition that may impact on his or her participation during initiation. So we say the fact that the medical certificate must be treated confidential by everybody doesn't mean that you do not have to comply with obtaining the medical certificate. Then clause 4, honourable chair and members, it deals with the establishment, the composition, and the term of office of the National Initiation Oversight Committee. In paragraph A, we are changing the 2 members of the National House to 3 members. In paragraph F, we are changing the title or the name of the Department of Women to the correct name as it is after the 2019 elections. Honourable members will remember that we mentioned last week that at the time that the bill was tabled in Parliament, it was only the Department of Women, but that portfolio changed last year, so we are just correcting that. In paragraph H, there's no change in the paragraph as such, except for the word "and" that is removed at the end of that paragraph. Paragraph I includes the representative from Department of Sports, Arts and Culture. And then the existing paragraph I, of course, then must change to become paragraph J. The next amendment, which is to subclause 4, is then a consequential amendment to say instead of referring to paragraph 1H, it must be paragraph. We'll see later on there's another clause where these consequential amendments will have to be made. Chair, then in clause 5, which is about the chair and the deputy chairperson of the NIOC, the National Initiation Oversight Committee, the introductory part of subclause 1 is to be changed to say that at the first meeting of this NIOC, that this meeting must be convened and chaired by the Minister, or then by the Director General, if so directed by the Minister. Then we move to clause 15, which is the functions of the Provincial Initiation Coordinating Committee. There's 2 changes. The one is in paragraph E. So if you read the introductory part, it says a Provincial Initiation Coordinating Committee must coordinate all initiation schools, practices and activities within the particular province, and must then for this purpose, now in paragraph E, it then says the PICC must determine the number of schools to be allowed, and they must take into account criteria, which will then include the availability of proper habitable structures conducive to initiation practices. We're removing the word and it will continue to say the provision of municipal services to such schools, and then the new part that's added is to say and accessibility of the schools. Then, Honourable Chair, in paragraph G, this is where we included the definition. Honourable members will remember there's a new definition for standards for initiation school premises, and we're including it in this paragraph to say that the PICC must develop criteria and requirements with which these schools must comply. And this must include health, water, sanitation and safety requirements, and they must take into account the standards for initiation school premises, insofar as those standards are not inconsistent with this Act. Then, Honourable Chair, the next clause is clause 21. It deals with principals and caregivers. The particular amendment is to subclause 10. And based on that insertion there, it will then read to say a principal must inform all role players involved or in initiation of the initiates who have disabilities, and must ensure that the needs of these people are taken care of, including the provision of sign language practitioners and braille services where it is applicable. Clause 22 is about parents or legal or customary guardian. Here we have accommodated the committee's decision last week to say that a medical certificate, when a medical certificate is obtained, it must be obtained from a medical practitioner who is practicing in that particular province where the initiation school is located. This is to address the issue that was raised that initiates get a medical certificate from somebody in Gauteng, but they attend initiation school in Eastern Cape, for example. Then the next one, all the rest of that clause is not affected. Then clause 24, medical practitioners, subclause 2A, paragraph A is to be amended to state that the medical practitioner must perform circumcision not on any male initiate, but on the relevant male initiate for which this medical practitioner was taken to the 10 prohibitions, age and circumcision. I've quoted the whole subclause 5 there for the purpose of the honourable members, but the actual amendment is in paragraph D. I remember this was proposed by quite a number of provinces and raised last week in the meeting. And the amendment is quite a straightforward one, is to say that no child or other person may be forced or coerced to undergo virginity testing as part of initiation. Clause 31, that deals with the death of initiates. This is about in paragraph B, subclause 2, paragraph B. This deals with the counseling that must be provided if an initiate unfortunately dies. And the part that is added is to say that it's not only the initiates that must be counseled, but also, if requested by them, the parents or the legal or customary guardian of the deceased initiate. Clause 32, Honourable Chair and members, deals with allowances and expenditure. Now, this is only relating to those 2 additional members that may be appointed as members of the NIOC. And this is a technical or a consequential amendment. It is because of that insertion in the membership of the NIOC where we added the representative of the Department of Arts and Culture, which means that the existing paragraph I now becomes paragraph J. So this is a cross-reference that has to be changed both in subclause 1 there and in subclause 2. Then clause 33 deals with offences. This one is also about the definition that we included, or words physical or mental can be removed in paragraph D of this particular clause. The last one is the short title and commencement, clause 42, similar to what Dr. Naidu proposed, and that is that we changed the number of the Act from 2018 to 2020. Thank you, Honourable Chair, and thank you to the Secretariat for moving the presentation upwards there. Thanks.
Thank you very much, Mr. Bester. Honourable members, that's it. Those are the proposed amendments to the customary initiation bill for consideration by the committee. Any input or comment from Parliament, the Parliamentary Legal Advice Office?
Good evening, Chairperson, and all the honorable members and everybody present. Chairperson has indicated we worked together on the proposed amendments and we had discussions, so everything is above board and we are in agreement. Thank you, Chair.
Oh, thank you very much. I like that spirit of working together between the legislature and the executive. We need to do that so that we share information, experiences, and expertise. You're doing us a good job. Any contributions, questions, comments from honourable members?
Chairperson.
Honourable
Chair. Yeah, before we comment, is a representative from the Office of the State Law Advisor present? And perhaps if they have a comment before.
Yes, Honourable Chair, Ms. Harriet Mekwa is present.
Yes, any comment from the Office of the State Law Advisor, if any? Silence means consent. It means
No,
the
Chairperson, good evening. It's no, Chairperson, I do not have any comment at this stage because it is a consolidated document with all our inputs in it. Thank you.
Okay. All right, thank you very much. Honourable members, that's it. The floor is yours. I open this for comments and discussions or even questions from honourable members. Are you okay?
Honorable Chair.
Honourable Chair of the Portfolio Committee, Honourable Sandana.
I just want to thank you and the presenter for the clean and direct and easy understandable presentation. This is just from me and on behalf of the Free State. Thank you, sir.
All right, thank you very much, Honourable Sandana. And you are one of the provincial representatives who work tightly and closely with us, and we really appreciate that. Any other comments from honourable members? If we are satisfied, we need to move towards the adoption of the report and the proposal.
Can I move for adoption, Chair?
We are
Yes.
fine, Chair.
In case that there are no comments, you are all satisfied, honourable members?
Yes, Chair.
We will move along those lines. Honourable Martha Bartlett has moved for the adoption, and Honourable Ethel Nkosi has seconded the move for the adoption of the report. Any objection? Any objection? Any abstention? Are we all happy? Okay. This has been adopted, has been accordingly adopted. Initially, in respect of the Municipal Structures Amendment Act, I indicated that once this adoption is finalized, we take in this matter to the House. I made that technical mistake. As you are aware, the two bills will be taken back to the 9 provinces for the last mandate, and that process will take about a week or so before it comes back to us, and thereafter taken to the House. I made that technical error in terms of the process, but I've since rectified that. On the basis of that, let me just reinforce what I've said. We have adopted the two bills as this committee. We are taking them back to the provinces for the final mandate before they come back for us as the NCOP for the adoption. On that note, let me thank all of you, honourable members, for attending this meeting. I know that this has been a very, very, very long day, but you managed to sustain it. And let me also take the opportunity to thank the DG of COCTA, as well as the representatives from Parliament, as well as from the Department of COCTA as well for attending this meeting and sharing with us the necessary information. On that note, can I adjourn the meeting? The meeting is closed, and thank you very much, all of you, for honoring our invitation to this meeting and participate quite meaningfully to ensure that we do what is expected of us as the House of Parliament. Thank you very much. The meeting
Thank you very much.
Thank you, Chairperson.
Thank you,
very much.
Thank you, Chairperson.
Thank you for the
Bye,
invite.
everybody.
Bye-bye, everyone, honourable members. God bless you all.
Bye-bye, members.